Hearing in the appeal of Maduro board against Guaidó board.
Now, if you can just give us a moment, we're going to have to set up our laptops. Now, before we begin the submissions, it seems to us that it might be helpful to have a brief discussion of some housekeeping matters at the outset so that we know what the structure of this hearing is going to be and have, as it were, a route map. It's not ideal because of the way you're socially distanced. I see Mr. Vinell's in the second row, for example, and Sir James also. What has struck us is that in light of the way matters have developed, particularly following the intervention by the Foreign Secretary, the scope of the reality of the dispute seems to have narrowed. And if we were looking at the issues as identified in the statement of facts and issues, if I can just find that.
Page 1975.
Assistance.
Yes, thank you. Now, there are three grounds on which the Guaidó board has been granted permission to appeal. Now, the first of those has to do with whether the Court of Appeal erred in its interpretation of the statement or various statements made by the Foreign Office at earlier stages in the proceedings. And it seems to us that that issue may have been superseded as we now have a very clear statement of the Foreign Secretary's position in the intervention, and there's no magic in the documentary form of the earlier statement. The second issue, whether the Court of Appeal was wrong to conclude that was the issue of de facto recognition. Now, I think it's, if we've correctly understood the case on behalf of the Secretary of State, there's no question of de facto recognition. So that issue seems to us also to have been superseded. And the remaining issue raised by the Guaidó parties, issue 3, seems to us to be the central question in the appeal. And if that's right, then that's the one we would want to be focusing on in the submissions on behalf of the appellant. And then, of course, the Maduro board's cross-appeal also concerns the issue of act of state. So that issue of act of state, and in particular the implications of the various decisions of the Supreme Court in Venezuela, seems to us to lie at the heart of this hearing. Now, we also have supplementary cases in which the Maduro board raise two further questions. But as we understand the position in the light of the latest correspondence, we don't understand the Maduro board to be wanting to argue those in this hearing. The first of them is again a question of de facto recognition, and the Foreign Secretary has made it clear that's not what this is about. And the second issue, effectively a challenge to the rationality of the recognition of the Guaidó board, we don't understand the Maduro board wishing to argue in these proceedings. Now, if we've misunderstood the position, do let us know. But I think it's a good idea for us, as it were, to clear the air at the beginning and be clear about where we're going, because the most profitable use of the time, as we see it at the moment, is to focus on the active state issue. Obviously, we've read really quite lengthy written cases on behalf of all parties, and what we would really benefit from is analysis of the central authorities on that issue. I hope that's helpful.
That's extremely helpful, my Lord. Thank you very much indeed. And we respectfully agree with your Lordship's preliminary analysis as to what this appeal ultimately comes down to. I had characterised in the submissions that I had drafted to present to the court today the question arising out of the Foreign Secretary's case, and in particular paragraph 41 of the Foreign Secretary's case, as a supervening issue, which had in substance answered the question posed by the Court of Appeal, thereby disposing of the recognition issue in our favour. I had prepared submissions to support what we contend to be and to have been the four errors in the approach of the Court of Appeal below, in case the court wished to grapple with those, this being an opportunity to do so in circumstances where it may be, and this is a matter for Sir James, where it may be that questions of recognition form an increasing component of United Kingdom foreign policy, and therefore it's appropriate that the courts know, for example, whether our submission about Four Corners interpretation is correct or not. And I'm prepared and ready to deal with each of those four errors as we submit them to be, as well as the supervening issue. But I would go at a speed which I hope would be commensurate with the analysis that my Lord has just put to me. I'm also in a position to address and deal with, and I would respectfully submit, dispose of, the proposed rationality challenges. And again, we would submit with respect that it is appropriate that the court grapple with that.
Well, we don't even have jurisdiction.
Well, quite, my Lord.
In this form of process.
And as my Lord has seen from our written submissions filed on the 12th of July, we invite the court to dismiss the application for permission to raise these two new arguments on two bases. Firstly, lateness, and secondly, lack of any real prospect of success.
Yeah. Well, we'll have to hear from Mr. Vinyl whether he's even seeking to introduce these additional grounds.
My Lord, yes. If the court wishes me to at least touch upon those in the course of my oral submissions, then it would be proposed that I do so, and that indeed Sir James do so tomorrow too, when he makes his submissions. Now, Mr. Vinyl's proposal, as communicated, as we understood it, by the letter that came in at 5 o'clock on Friday evening, was that this might not arise at all, and so best leave it till the end of the third day, and we can then decide and perhaps take a fresh run at it on Friday. Now, we respectfully submit that isn't a helpful way forward, and it wouldn't be an appropriate way forward in circumstances where Sir James is not available, certainly on Wednesday and possibly on Thursday. And if challenge of this substance is to be advanced, he should have the opportunity to say what he wants to say about it. So that is the course that I was going to propose, my Lord, and I'm entirely in your Lordship's hands, was to go through the 4 errors, to address the supervening issue, and then to hand over to Mr. Fulton to deal with what is ultimately going to be the determinative issue, we say, in this case. I'm tempted to sit down now and hand over to Mr. Fulton, but that might not be entirely fair on him, and for the reasons of principle that I've sought to articulate, we do submit that it is an appropriate opportunity for the court to grapple with the correct approach to interpretation. And indeed, it may be that looking at some of the authorities on interpretation, whether Kellington, whether Carl Zeiss, whether Aranzazu Mendy, is helpful in setting the landscape for what then becomes the crucial battleground on foreign act of state.
I think we're obviously going to have to hear from Mr. Vinall and Sir James, and where they are sitting, they can't be picked up by the microphones for the live stream of this hearing. So I'm afraid I'll have to ask
Shall I step to one side,
Mr. Fulton to step to one side,
certainly,
so that we can hear what the other party's position is. I think it might be best to hear first from Sir James.
Well, yes. Our position is that we're entirely in the court's hands. It would obviously be helpful, given the disagreement between the parties, or some of the parties, and the approach of the Court of Appeal, for the court at least to consider whether it wishes to consider and to give judgment about, perhaps not reaching a final conclusion on that immediately, but it's for you whether you want to receive submissions on that. We're ready to assist in any way that would suit. It would obviously be helpful for us to know from Mr. Vinall whether he is actually running what might be called the nuclear challenge, which says you do have jurisdiction to go there and you should, and rationality is the test, because I've certainly got some things to say about that if that position is going to be argued. I'm not entirely sure what the position means that says we're going to wait and see how the argument develops. He's either taking the point, it seems to us, or he isn't. And if he is, it's up to the court as to whether or not it wishes to hear about it. I've got nothing to say beyond the very brief submissions I made on foreign act of state, although that's obviously a matter of importance to the government more generally. But I was not planning to add to what we'd said briefly in writing on that in oral submissions. So I'm really here on the recognition and interpretation questions and the base challenge, if that is to be run.
Yeah. If that is to be run, are we right in understanding that you're not available Wednesday and Thursday?
My Lord, I'm not, and I'm very sorry about that. I know this court trumps everything, but it was
it's not been anticipated we would be going into Thursday.
No, so, but I'm very happy to make whatever submissions I need to make in the first couple of days and then leave it to others.
Yeah. And so far as the Court of Appeal is concerned, on issue 1, on one view, it's water under the bridge. But on the other hand, if what they said is liable to cause continuing problems, then I can see there's a point in our hearing submissions on the matter and either approving or disapproving of their approach.
I mean, that is the broader worry, is that if you just simply leave it and move to foreign act of state, then the latest and highest authority will remain.
Yeah.
And it seems very unsatisfactory with respect, perhaps, for the Supreme Court to say, well, we don't need to go there in the light of the supervening event, but that's obviously a course which is open to you. Yeah. You know what we've said in paragraph 41 of our case. I don't know whether submissions are going to be made as to whether or not it is open to us, as it was when various Attorney Generals addressed various courts in the 1920s, and even Counsel for the Treasury addressed various courts in the 1920s. Whether there's going to be a point taken that we can't do it that way, we can't provide the clarification. But, my lords, as I say, I'm in your hand. My preferred position, if I'm allowed to state one, would be that this court does clarify the correct approach to interpretation, but we can no doubt take that at commensurate speed.
Yes. Yes. Thank you very much, Sir James. That's very helpful. Mr. Vinall.
Well, Lord, I think I need to address 3 questions. One is, what, if anything, needs to be resolved on recognition and the consequences of recognition? The second is the issues of act of state. And the third...
Can I stop you there? Could you go between the two microphones? We're losing you when you're speaking. Thank you very much, sir.
The second is act of state.
Yes.
And the third is the new challenges.
Yeah.
And I divide the points up like that in order to emphasise that the new challenges are new points on recognition and its effect, but are quite separate from the main points that we wish to make on recognition and its effects. And can I just say immediately at the outset, we do not at all accept that the new statement or explanation given by the Secretary of State is fatal to the Maduro board's case. Indeed, we suggest it supports the Maduro board's case. Now, can I very briefly explain why that is? Because if that is a live argument, and we say it is, in our submission we will need, very much need, to deal with issues 1 and issues 2. At absolute root, we say this is a case about sovereignty and about power in Venezuela. Traditional recognition statements have been recognition statements in relation to governments. There is no recognition statement in this case in relation to governments. And if we are right, that means that the position remains that Mr. Maduro is in effective control in Venezuela. One then has to ask carefully, well, what is the recognition statement that has been made by the Secretary of State, and what is its consequence? And what your lordships will have seen is that the recognition statement that has been made is about Mr. Guaido's position as President of Venezuela qua head of state, his position as head of state. And you will have seen repeated references to the expression representing Venezuela on the international plane. We say this case is essentially about the domestic affairs of Venezuela and the appointments domestically to a domestic Venezuelan body. And therefore, we contend that there is nothing in the Secretary of State's new recognition statement insofar as it is new, nothing in his statement that Mr. Maduro is no longer recognized as head of state, which touches upon or determines the authority question, which is a question about, we say, sovereignty within Venezuela. So for those reasons, we would respectfully suggest that issues 1 and 2 remain most definitely live and kicking, and we would very much want to develop our arguments on those issues. Issue 3 is act of state, and we respectfully agree that whatever the outcome on issues 1 and 2, the act of state issues arise. We said something in our case about whether or not this was the appropriate stage for them to be dealt with when no facts have been found, and that's something I'll come back to, but certainly if the court is against me, and from what your lordship has said, you may be against me on the appropriateness of dealing with that now, obviously we need to deal with those issues.
Not at all. I make that clear. I mean, it's very much a question as to whether effectively, whether evidence is required on and findings in fact on bearing on the what weight should be given to the decisions of the Supreme Court.
Yes, but in any event, act of state will at some level need to be dealt with. So then the third issue I need to deal with is the new points which we floated. And again, I emphasize these are new points in addition to the case I very briefly described on recognition and the effects of such recognition as has been given. And perhaps I can just spend a few moments on that, but in fact, Lord Reed, the way in which you summarised it is essentially right. I don't think that we do need to raise those points, but can I explain why, what they were, and why we think we will not need to advance them? As you know, the Court of Appeal's disposition was that matters would be remitted with the government given a further chance to explain its position. And instead of that, we've come on an appeal, and in December you invited the government to consider whether it wished to intervene, and it did so, eventually on the 18th of June. And obviously it's quite unusual for the raw material which the court is dealing with in this court to change at the last minute, but in a way that's just tough when it's a recognition case and the parties have to deal with that. The new submissions, or the intervention from HMG, does, we say, introduce new features or at least new nuances into the government's position, two in particular. Firstly, repeated focus on Mr. Guaido's entitlement to represent Venezuela on the international plane, a formulation absent from any earlier HMG statement on the status of Mr. Guaido. And secondly, the explicit statement, it's at paragraph 41, just for the reference, it's hearing bundle 2147, that from the 4th of February 2019, quotes, HMG no longer recognise Mr. Maduro as the Venezuelan head of state. And I emphasise, as the Venezuelan head of state, not HMG no longer recognised or does not recognise Mr. Maduro as the Venezuelan head of government. So we take the view, and took the view, that that in fact assists the Maduro board's position, because it makes crystal clear that HMG is not saying anything about the effective control of the organs of the state in Venezuela. But if we were wrong on that, if we had misconstrued the position, and if HMG were in fact saying something about the actual exercise of power by Mr. Guaido in Venezuela, then we would be very concerned with that. And it was because of that concern that we raised the two new points. And the two new points were, and I'll take the second one first, it's the more profound of the two, and it's been described already as the nuclear option. That was that if there is an exercise of the prerogative to recognise, which depends on treating as true a fact which is manifestly false, not false on the balance of probabilities, but manifestly false, then such an exercise of the prerogative is open to review. And we recognise that that argument raises sensitive and obviously potentially difficult questions. The first of the two arguments was an argument specifically about the one voice doctrine, and it operates independently of the second argument, and it says that even if the exercise of the prerogative of recognition is not in any way reviewable, nevertheless it does not follow from that, from non-reviewability, that the courts are bound by the one voice principle to treat as true a fact which is manifestly untrue. In other words, it posits a position in which the exercise of the prerogative remains, but when the courts are dealing with a question which requires a determination of some fact, that exercise of prerogative can't oust the court's jurisdiction to decide facts. However, having raised those arguments in our supplementary case, we took great comfort from the responses which came from the other parties. The Guaido board, and this is, I'll give the reference, it's hearing bundle 2, page 30, but they say now that the fact which is being certified is the fact of recognition. Don't seem to go any further than that. That's fine from our point of view. And HMG say, and this is para 2.2 at bundle 2, page 41, that neither the Foreign Secretary's certificate nor his case purport to certify whether Mr. Maduro or Mr. Guaidó is exercising particular powers in Venezuela. So as we understand the position, nothing is actually being said about the factual position in Venezuela, and it is not suggested that there is any one voicing out of contentions that might be made in relation to that. And so, as we indicated on Friday, having considered the responses, so long as that remains the position, we do not need to run either of those arguments, and indeed cannot run them, because their premise is one that is false.
Yeah.
So, my Lord, that's perhaps too long a way of saying yes to your Lordship's point on that. But perhaps the most important thing is that on issues 1 and 2, it seems to us there's a great deal that remains to be said.
Mm-hmm. Yes. Well, thank you, Mr. Vinell. That's very helpful. Well, I certainly, Mr. Rotti, share Mr. Vinell's understanding of the position adopted by your clients and also by the Foreign Secretary, that no assertion is being made that Mr. Guaidó effectively exercises control of the bank's affairs domestically.
No, my Lord, for the purposes of one voice and recognition, that's right. Obviously, the very reason we're here is that Mr. Guaidó has purported to exercise at least one power in the possession of the President, namely to appoint the board.
Yes.
But so far as this issue of recognition is concerned, that's right, my Lord. And that's why we said, as soon as we saw these arguments presented by the Maduro board, that they proceeded from a false premise.
Yes.
And I'm glad that we've comforted Mr. Vinell in that regard.
Yes. Well, it sounds in that case as though the supplementary argument simply won't arise. Obviously, if it did arise, there would then be a question whether we were going to allow them to be advanced. But it sounds as if they simply are aiming at a target that isn't there.
That's our primary position, my Lord, yes.
Fine. Well, I think it might be helpful if we were to adjourn for a few minutes to discuss amongst ourselves what we've heard,
Of course, my Lord.
And that'll give Council also a chance to consider the submissions they were planning to make in light of what.
Thank you, my Lord.
Very well. We'll adjourn for a short time. Well, having discussed matters, we're content to proceed in the way that's been discussed. In other words, we'll hear you on all issues. You've obviously heard what we had to say about them, and will no doubt take that into account. We don't understand as the supplementary issues are going to arise in the light of the position adopted by the Guaidó board and the Foreign Secretary. Can I also remind members of the public sitting in the public benches to wear masks? We have a responsibility to protect our staff who come into contact with members of the public, and we don't know who's been double jabbed and so forth. So it's a necessary precaution. Mr. Rotti.
Thank you, my Lord. My Lord, as the Court is, of course, well aware, this appeal concerns the identification of individuals entitled to give instructions on behalf of the Central Bank of Venezuela in respect of substantial assets of the bank in this jurisdiction, and questions of both recognition by Her Majesty's government and foreign act of state. Those issues fall to be considered against the background of a statement made to the Commercial Court by the Foreign and Commonwealth Office on the 19th of March 2020, and now also supplemented, as we've just been considering, by the contents of the Secretary of State's printed case on this appeal. The March 2020 statement was itself made in reply to correspondence from Mr. Justice Robin Knowles, and the Court will have seen that his letter and the statement are set out at paragraphs 7 and 8 of our printed case. The central issues which arise for determination by the Court are the extent of recognition which Her Majesty's Government has given to Mr. Guaidó as President of Venezuela, the application of the so-called one voice principle flowing from such recognition, and the nature and application of the doctrine of foreign act of state. The Guaidó Board contends, with respect, that the Court of Appeal's approach to these issues was overcomplicated and flawed. It submits, in common with the Secretary of State, that there is, on a proper analysis, a relatively short and straightforward route to resolution of this appeal, and that would have been the case even without the supervening issue that we've been discussing this morning already. On its natural and ordinary meaning, the March 2020 statement was unequivocal and unambiguous in its recognition of Mr. Guaidó and no other as President, as Mr. Justice Tier held, and as we have sought to explain in summary at paragraph 9 of our printed case. As a result of the one voice principle, we submit that that determines what is described in the Statement of Facts and Issues as Issue 1, the primary recognition issue, in the Guaidó Board's favour. It renders irrelevant Issue 2, relating to cases where there is competing de facto and de jure recognition. And it also renders the appointment of the Guaidó Board by Mr. Guaidó a sovereign act which the English courts are required to treat as valid and effective for the purposes of Issues 3 to 8, the Foreign Act of State issues. And as we explain at paragraph 10 of the printed case, the Court of Appeal, however, took a different course. It held that the March 2020 statement was ambiguous, or at any rate less than equivocal, and it left open the possibility that Her Majesty's Government may impliedly recognise Mr. Maduro as President de facto. That meant that the Court of Appeal could give no definitive answer to the recognition issue, and that in turn meant that the Foreign Act of State issues could not be resolved either. The Court also concluded that no answer could be given to the Foreign Act of State issues without considering the extent to which decisions of the Supreme Tribunal of Justice of Venezuela, the STJ, should be recognised by an English court. Now, as we explain at paragraph 10 of our printed case, the Court of Appeal reached its primary conclusion on recognition by reference to 5 specific aspects of what it described as relevant context, and which it set out at paragraph 123 of the judgment. The Guaidó Board submits that the Court of Appeal's approach to the recognition issue involved 4 significant errors that we've summarised in paragraph 13 of our printed case. First, as I've already indicated, there was a straightforward failure to give effect to the plain and unambiguous meaning of the words used in the March 2020 statement itself. Secondly, there was a flawed approach to the admission of extraneous evidence in that exercise of interpretation, so as to create, in the Court of Appeal's view, a possible ambiguity where, on a properly focused inquiry, there was none. The approach was flawed, we say, because 4 of the 5 matters of context relied upon by the Court of Appeal were not referred to in the March 2020 statement at all. And the Court should instead, we say, have focused only on what was within the 4 corners of the Court's letter and the March 2020 statement. Thirdly, there was an unjustified reliance on a far from established notion of implied de facto recognition in circumstances where the concepts of de facto and de jure recognition have, we say, always lacked clarity, and where, we say, they have no useful role to play in a judicial context today. And fourthly, there was an unjustified conclusion that even if it were permissible to have regard to them at all, any of the 5 contextual matters set out in paragraph 123 of the Court of Appeal's judgment, rendered the March 2020 statement ambiguous or at any rate less than unequivocal. They were each, we say, either analytically irrelevant or neutral, and entirely consistent with the full recognition which the words of the March 2020 statement indicated had been given to Mr. Guaidó. But as I've already said, as a result of the content of the Secretary of State's case on this appeal, there is now the supervening issue, which also falls to be addressed. By the statements made throughout the Foreign Secretary's printed case, it's not just paragraph 41, but throughout the Foreign Secretary's printed case as to what was intended by the March 2020 statement, and by that further express statement at paragraph 41, Her Majesty's government has now effectively and directly rejected the possibility identified by the Court of Appeal in its judgment as being left open as to Mr. Maduro's status, namely the possibility that Her Majesty's government may impliedly recognise Mr. Maduro as de facto president. And Her Majesty's government has in substance answered the further questions indicated as necessary by the Court of Appeal. That makes it, we submit, impossible for the Maduro board to succeed on the primary recognition issue, subject only to the irrationality challenges which appear now to have fallen away. Indeed, the Maduro board's supplementary case comes quite close, doesn't go quite as far, but comes quite close to accepting this by acknowledging at paragraph 1710 that the statement in the Foreign Secretary's printed case that from 4th of February 2019 it no longer recognised Mr. Maduro as head of state in any sense prevents the Maduro board from arguing that there is an implied parallel recognition of Mr. Maduro as being the head of state. Now, it appears from what Mr. Vinal has said that there's going to be an attempt to dance on the head of a pin and distinguish between head of state and president, but as we'll see, that argument just won't work. So events have moved on, my lords, since the case was before the Court of Appeal. And even if its approach had been correct then, the issue is now settled. There is, on any view, no possible basis for finding any form of subsisting recognition of Mr. Maduro by Her Majesty's government. And the Foreign Secretary has made it clear, we would say made it clear again, that Her Majesty's government recognises Mr. Guaidó and only Mr. Guaidó as president. Now, the Maduro board apparently seeks, and we'll see how Mr. Vinal puts it in due course, but apparently seeks to sail serenely beyond all of this by asserting that the position is as if no statement as to Mr. Maduro's lack of status had ever been made. But that is to ignore the fact that where there is a departure from the 1980 policy, express statements of non-recognition are as significant and as entitled to respect as express statements of recognition. As I've indicated, my lords, I propose to address the Guaidó board's position on this supervening issue first, before turning to each of what we submit to be the Court of Appeal's 4 errors in turn, addressing the response of the Maduro board to the extent it engages with them as I do so. And then, if necessary, and if the court thinks it helpful, but it probably won't be in the light of the exchanges so far, to say something about irrationality. If time permits, and subject to the court's wishes, I can also address issue 2, but again, it seems to us that that issue has largely fallen away. And Mr. Fulton will then address the court on behalf of the Guaidó board on the Foreign Act of State issues. Before, my lords, embarking on that course, and by way of overview, in relation to both recognition and Foreign Act of State, I'd like to flag at the outset, if I may, what we submit to be 6 basic flaws in the approach of the Maduro board in the stance it has adopted throughout these proceedings, and which indeed continue to be reflected in its written case and most recently in its supplementary case. First, the primary, or at least a substantial focus of the Maduro board's printed case appears to be on an asserted issue as to the identity of the government of Venezuela and what constitutes recognition of a government of a state as a matter of international law. That is, as Mr. Justice Tier agreed, to shoot at the wrong target. That's Mr. Justice Tier, paragraph 34, Appendix 227. It's common ground that each of the Maduro board and the Guaidó board traced their claim to authority through presidential appointments. That's reflected in the Court of Appeals judgment at paragraph 3. It's reflected in the Statement of Facts and Issues at paragraphs 4 to 7. And it follows, we say, that all that matters is the identity of the president. So that's the first basic flaw. Secondly, the Maduro board's case appears to proceed on the basis that there had, prior to February 2019, been some express recognition by Her Majesty's government of Mr. Maduro as president, such that an express statement of derecognition was required in order for any material change to have occurred in the present context. Now that, we submit, was always a false premise. Consistent with the 1980 policy announcement, there had been no prior recognition statement in relation to Mr. Maduro at all. As the Court of Appeal correctly stated at paragraph 123 of its judgment, what had gone on before was at most more accurately described as a course of conduct involving unequivocal dealings with him as head of state, dealings being distinct, of course, from recognition, a distinction recognised in the 1980 policy statement itself. So that's the second basic flaw. Thirdly, there is no adequate engagement in the Maduro board's printed case with any of the authorities that we have cited, showing the inappropriateness of a wide-ranging inquiry into factual background to determine the meaning of authoritative recognition statements by Her Majesty's government in this area. The four corners point, as we've summarised it. Fourthly, the Maduro board places what we say is quite unsustainable weight on the question of diplomatic relations and dealings since February 2019. The individual diplomats referred to by the Maduro board were accredited prior to the material date of recognition of the 4th of February 2019. Their positions and any diplomatic dealings since then are not referred to at all in the March 2020 statement. And the March 2020 statement was instead explicit that nothing had materially changed in terms of recognition since the statement made on the 4th of February. Fifthly, my lords, and so far as act of state is concerned, the Maduro board appears to take on an ambitious and we would say unrealistic challenge for which no permission to appeal has been granted, in seeking to show that the Foreign Act of State doctrine, considered and explained as recently as the Belhaj decision in 2017, should in fact now be held to have no existence at all, on the basis, as the Maduro board puts it, that it is unclear, unprincipled and unnecessary, and lacks any coherent justification. And sixthly, again in the context of Foreign Act of State, in seeking to emphasise the importance of the decisions of the STJ, the Maduro board fails adequately to confront the fact that Mr. Guaido's appointments of the Guaidó board and the Special Attorney General were sovereign acts, which an English court must respect, irrespective of their domestic law validity or legality. The consequence, we say, of Her Majesty's government's recognition of Mr. Guaidó is that his sovereign acts must be treated as acts of the Venezuelan state. Judicial decisions sit on a different plane to executive or legislative sovereign acts. They are not acts of state, and they cannot be elevated above executive or legislative acts in the manner the Maduro board's argument suggests. And notably in this regard, the Maduro board makes no attempt to suggest that the Court of Appeal's decision on this issue in UKOS is to be overturned or is wrong. So those are the 6 overarching flaws across the field that we rely upon, my lords. Turning then to the supervening issue, as the court has seen at paragraph 124 of the Court of Appeal's judgment, it summarised the consequences of its finding that the March 2020 statement was unambiguous or at any rate less than equivocal in the following terms. This is Appendix 1, Tab 2, page 68, if the court doesn't already have it to hand. Accordingly, the statement leaves open the possibility that Her Majesty's government continues to recognise Mr. Maduro as president de facto. And then again at 126, little Roman 3, the Court of Appeal stated that while Mr. Guaido's recognition was conclusive for the purposes of determining who is the de jure president of Venezuela, it leaves open the possibility that Her Majesty's government may impliedly recognise Mr. Maduro as the de facto president. Now, as I've said, and as has been made clear in our printed cases, both the Guaidó board and the Foreign Secretary dispute that conclusion as a matter of interpretation. But if one then turns from paragraph 126 of the Court of Appeal's judgment to what the Foreign Secretary's printed case says at paragraph 41, which is core volume, page 2147, that possibility, if it ever existed, has now, on any view, been removed. As paragraph 41 says, the Foreign Secretary, on behalf of Her Majesty's government, hereby confirms that the UK recognised Mr. Guaidó as the interim president of Venezuela on the 4th of February 2019 and continues to recognise him in that capacity. From that date, the United Kingdom no longer recognised Mr. Maduro as the Venezuelan head of state, whether de facto or de jure. And as is made clear, my lords, throughout the Foreign Secretary's submissions on the issue of interpretation in the remainder of his printed case, that is what the Foreign Secretary believes was said in the March 2020 statement too. Key passages in the Foreign Secretary's case, aside from paragraph 41, making clear that Her Majesty's government, what Her Majesty's government intended by the March 2020 statement, are at 3.1 on page 2133 of the bundle. The language of the certificate communicated Her Majesty's government's recognition of Mr. Guaidó in place of Mr. Maduro from 4th of February 2019 onwards. The consequence is that from that date, Mr. Guaidó and no other was the individual recognised by Her Majesty's government as having the authority to act on behalf of Venezuela in the capacity of head of state. 33.1 at page 2145, 33 little Roman 1. The certificate is unambiguous. And then at little Roman 3, Her Majesty's government's conduct more widely is consistent with Her Majesty's government's recognition of Mr. Guaidó as constitutional interim president of Venezuela to the necessary exclusion of Mr. Maduro as president in any capacity. Paragraph 35, same page. The certificate's clear meaning was that Mr. Guaidó was recognised by Her Majesty's government as head of state for all purposes for which a head of state can act. 36, it is clear that one president and one president only is recognised. Her Majesty's government did not purport to recognise Mr. Maduro in a residual or other capacity. On the contrary, the plain meaning is that Her Majesty's government chose not to do so, and that Mr. Maduro is not recognised. 39.1, the legal context, which of course I'll come to, the legal context provides further support for the clear recognition of Mr. Guaidó. Language of recognition is typically understood to refer to full recognition, not a lesser kind of de jure recognition or de facto recognition. That's page 2146. Paragraph 42, Mr. Guaidó and no other was the individual recognised by Her Majesty's government as having the authority to perform the functions of head of state. 43, page 2147, to the extent Mr. Guaidó exercises his authority Her Majesty's government will recognise that as an exercise of authority by the head of state of Venezuela. 45, next page, necessarily implicit, essentially mirroring the wording of Mr. Justice Tier, necessarily implicit in the certificate is the non-recognition of Mr. Maduro as the constitutional head of state of Venezuela. He may in fact be exercising power across a more or less broad sphere, but that is irrelevant. Her Majesty's government has stated its intention not to treat him as having any constitutional authority or competence to do so. And then 64, the continued engagement with the Maduro regime in limited spheres says nothing about the recognition of either Mr. Guaidó or Mr. Maduro. That's 2155. So the possibility identified by the Court of Appeal as left open has, we would respectfully submit, been definitively eliminated, and the question it suggested needed to be posed has been answered. And subject to the spectre of the irrationality arguments, which appears to have disappeared, that should be the end of the recognition issue. And subject to the importance of the point and the importance of guidance being given, I entirely acknowledge my Lord Reid's observations about as to whether, if all of that were right, any more needed to be said. It's clear Mr. Guaidó is recognised in the capacity of president. There is no sense whatever in any of the language used by Her Majesty's government that his position or the recognition is to be treated as merely one of entitlement, as the Maduro board would contend. It is made explicit that there is no recognition of Mr. Maduro de facto or de jure at all. And it's made clear, and again I say we respectfully submit, made clear again, that Her Majesty's government considers all of this to have been the case since the 4th of February 2019. Paragraph 41, of course, also provides what the Maduro board had previously contended in various parts of its printed case was necessary to remove Mr. Maduro from the field for the purposes of the present proceedings. An express statement of non-recognition or derecognition in relation to Mr. Maduro as from the 4th of February 2019. I don't need to turn them up, but the references to that point in the Maduro board's printed case are at 16, 17.3, 93 and 112. On the Maduro board's primary point, or one of their primary points in their printed case, Mr. Maduro has now indeed been removed from the field. Now, on this question of interpretation, and to apply words used in a different context by the Court of Appeal in the Gulf Centre for Human Rights case about the Ministerial Code, in a court comprising the Lord Chief Justice, the Master of the Rolls and Lord Hamlin, it would, we say, be perverse for the court to interpret the March 2020 statement in a way which the government has repeatedly stated was not intended. And again, I don't need to turn it up, but the reference, I think, to Gulf Centre is Supplementary Authorities, tab 2, page 4257. Now, we, of course, don't need to go as far as saying that the outcome that the Maduro board contends for would be perverse, and we can limit ourselves to the more modest submission that it's wrong. The Maduro board's response to this development, represented by the Foreign Secretary's case, is, as we understand it, threefold. Firstly, it claims that correctly understood, and you'll see, my lords, that these interpretation points are also set out in the Maduro board's supplementary case along with their irrationality challenges. First of all, the Maduro board claims that correctly understood, the Foreign Secretary's case does no more than confirm recognition of Mr. Guaidó in the Luther and Segor de jure sense described by the Court of Appeal, namely one attesting only to the question of entitlement. And as part of that argument, the Maduro board appears to contend that it is still open to the court to treat Mr. Maduro as president, notwithstanding the express statement of non-recognition that has been made. Secondly, the Maduro board contends that the Foreign Secretary's case only relates to recognition on the international plane. And we heard Mr. Vinyl on that giving a preview this morning, and so is irrelevant in the present context. And thirdly, it argues that if those submissions are wrong, then it might still have this irrationality challenge. But as I say, that appears now to have fallen away. So focusing only on the first two for the moment. So far as interpretation is concerned, and the attempt to cling on to a Luther and Segor form of de jure recognition relating to entitlement only, paragraph 41 of the Foreign Secretary's case could not be clearer. The Foreign Secretary has confirmed that the United Kingdom recognised Mr. Guaidó as the interim president of Venezuela on the 4th of February 2019 and continues to recognise him in that capacity. Not expressing a desire that he be president, not saying he's entitled to be president, recognising him in that capacity. There is no qualification in the statement, whether by reference to mere entitlement or otherwise. And then there is in addition the express statement that from the 4th of February 2019, Mr. Maduro enjoyed no recognition at all, whether de facto or de jure. A conclusion that Mr. Justice Tier, of course, had already reached by reference only to the March 2020 statement. Now, for the Maduro board to contend, as it appears to in paragraph 1711 of its supplementary case, that the court, or the commercial court, is now in a position where no statement at all about Mr. Maduro or de facto presidency has been made, so leaving it open to the court to explore this question afresh and perform some kind of cousin to the Somalia Woodhouse exercise, is, we respectfully submit, an argument which is an exercise in denial that has to be rejected. It fails to confront the unequivocal, unqualified, exclusive nature of the recognition afforded to Mr. Guaidó. And it fails to confront the significance of statements of non-recognition, such as that made in relation to Mr. Maduro, for the one-voice principle. As the Foreign Secretary's case has pointed out at paragraph 15 and footnote 3 of his supplementary case, when Her Majesty's government has issued a statement of recognition or non-recognition, and as the Court of Appeal's decision in the Kuwait Airways litigation shows, the court's only task is to give effect to it. So that's the first argument and the first attempt to get around the Foreign Secretary's intervention on the supervening issue. And that should, so far as interpretation is concerned, be that. But it's only underscored by the further passages from the Foreign Secretary's case that I've just taken the court through. There's absolutely no basis for the kind of ambiguity that Mr. Vinyl seeks to build. So far as the second argument is concerned, which is that, well, all that's been said is relevant to the international plane and nowhere else, that argument again misstates what Her Majesty's government has in fact said. As you've seen from the passages I've just pointed out, Her Majesty's government has made it clear it recognises Mr. Guaidó as president and will treat his acts as sovereign acts whenever he has purported to act. But more fundamentally, my lords, it fundamentally misunderstands the nature of recognition and how the one-voice principle operates. It is clear from the passages I've already referred to that Her Majesty's government's recognition of Mr. Guaidó's status is not as narrow as the Maduro board suggests. It's all-encompassing and exclusive. But in any event, while from Her Majesty's government's perspective, it's obviously conduct on the international plane which is of primary importance, and perhaps even the primary purpose in most recognition statements. That doesn't mean that they have no other purpose and no other consequence, as the Maduro board would wish to contend. The whole point about a recognition statement put together with the one-voice doctrine is that once Her Majesty's government has made its position clear as to who is, as a matter of foreign policy, and so far as the international plane is concerned, a head of state, the court must proceed from that starting point in resolving any dispute before it where the identity of the head of state is relevant. It's simply established as an uncontestable fact of state around which all the other issues in the litigation have to be determined. Otherwise, precisely the vice of the one voice principle that the one voice principle seeks to avoid would arise. Two different arms of the United Kingdom, deriving their authority from the sovereign, would be speaking with different voices. So, as I say, once the recognition has occurred, a fortiori, once the recognition has occurred in response to an express invitation from the court, where it's obvious to everyone that one voice is going to be in play, the courts are obliged to proceed from that starting point. And in this case, that starting point is that Mr. Guaidó and no one else is president and head of state in any issue before the courts. That is simply how one voice operates, for the sound constitutional reasons illustrated in the authorities before the court, and which I'll come to: separation of powers, avoidance of chaos and confusion, and so forth. So, in other words, that is all I was going to say on the supervening issue. It does indeed determine the recognition point in our favour, and none of the valiant attempts to evade it by the Maduro board have any merit. Turning then against that background and acknowledging that to an extent they're moot, but still of importance, I turn to the four errors that we submit that the Court of Appeal made in the judgment below. And the first, as I said, the question of basic interpretation. Each of the 10 points we make at paragraph 9 of our printed case is well-founded, we say. And taken together with the points that the Foreign Secretary's case has made, they lead to only one conclusion. There has indeed, since February 2019, been an unambiguous and unqualified recognition of Mr. Guaidó, and only Mr. Guaidó, as president. Now, the first of the 10 points, so this is on page 2000 of the core volume. The first of the 10 points concerns the content of the letter from Mr. Justice Knowles, which we set out earlier on in the case at paragraph 7. Four features from that letter stand out. Firstly, it asked directly about recognition, and it used the verb recognise, without any reference to concepts of de jure or de facto recognition, without any reference to concepts of entitlement or otherwise. Secondly, it made it explicit that it was being written because of an issue before the court as to who was entitled and authorised to act for the Central Bank of Venezuela. Thirdly, it asked Her Majesty's government to state, if a statement of recognition was to be provided, the date from which recognition commenced. And fourthly, the Foreign and Commonwealth Office would, on receipt of this letter, have known immediately that it raised an issue as to whether a departure from the 1980 policy of not according recognition was appropriate. And if that were the course taken, and a departure was made, that it at least could have implications in terms of the one voice principle. The second point of our 10 is at 9.2. The March 2020 statement, when it came in response to that letter, made it explicit that it was indeed being provided by way of departure from and exception to the 1980 policy of non-recognition. The statement referred to the 1980 policy, but then went on to say that it did not preclude Her Majesty's government from making statements of recognition where it considered this appropriate in the circumstances. And it then stated on the material point that in this respect, the court was referred to the 4th of February 2019 statement made by the Foreign Secretary recognising, I emphasise recognising, Mr Guaidó as the constitutional interim president, a statement which it then set out in full. Now that's significant, we respectfully submit, both in what is now common ground, that this was indeed a statement of recognition, that was still live before the Court of Appeal, and as a matter of interpretation. And as we've submitted in paragraph 9.2, exceptions to the 1980 policy occur when Her Majesty's Government wishes to inform the Court of what Mr Justice Mance described in the Kuwait Airways litigation as a more categorical attitude. The third point at 9.3 is that the statement did not, on its face, refer to the government of Venezuela or expressly state who was the head of any such government. It focused only on the identity of the president. And it was by reference to that point I've already made in my 6 overarching flaws, it was by reference to that point that in paragraph 34 of his judgment, Mr Justice Tier described the Maduro board as shooting at the wrong target, with its submissions as to who was or who was not the government, and what the statement did or did not say about that. All that mattered, and all that has ever mattered for the purposes of this present dispute, was whether there was an unequivocal statement as to who the president was. And of course we submit, and Mr Justice Tier held, there was. And as I've already said, this is an error of approach, shooting at the wrong target which persists today. Now, in its printed case, the Maduro board seeks to emphasise, at paragraph 85, that the statement did not directly answer all of the questions set out by Mr Justice Knowles, and to make some capital out of the fact that it did not state who, in Her Majesty's Government's view, was the head of government of Venezuela, or who was exercising what powers, and to suggest somehow that the Guaidó board had materially changed its case in this regard. And we've had a preview again of that from Mr Vinal this morning. Now, we respectfully submit none of those points are of any merit. First, as I've just said, what matters for present purposes, and all that matters, is the identity of the president, because it is in his capacity as president that Mr Guaidó has made the appointments he has. And indeed, it's only through Mr Maduro's alleged status as president that the Maduro board claims its authority. So the issues of government status, or who was or was not in fact exercising what powers, were simply irrelevant once Her Majesty's Government had taken a position on the presidency. Secondly, the suggested distinction between a head of state and a head of government has always, in this case, been entirely insubstantial. It is common ground that under Article 226 of the Venezuelan Constitution, the President of Venezuela is both the head of state and the head of the national executive. If, which is not the case, the English court needed to resolve a question as to who was the head of the national executive in Venezuela, it would have to conclude that it was Mr Guaidó, given the combination of that common ground and the express statement of Her Majesty's Government that he is the President. And that would be so whatever Mr Vinal were able to demonstrate about who was exercising which powers on the ground. And thirdly, my lords, we say, as the authorities show, Lord Wilberforce, which in Carl Zeiss, which I'll come to as a good example, provided what Her Majesty's Government has said is sufficiently clear on the material issues, ambiguity simply cannot be created by the fact that Her Majesty's Government has chosen not to answer some of the questions posed to it. Fourthly, to the extent it matters at this level, the Maduro board is simply wrong to say at paragraph 35 of its printed case that we had somehow abandoned an originally pleaded case. I won't take time going to the references for that, unless Mr Vinal returns to that theme. So the court needed only to determine who was the president or head of state of Venezuela, and that has been determined by the recognition statement. That person would in fact, and by definition also, as I've explained, be the head of the national executive, but that doesn't matter for the present proceedings. And that was all accepted and understood and endorsed by Mr. Justice Tier. That's our third point of 10 on basic interpretation, before we even get to four corners and some of the more important, perhaps, principles. The fourth point builds on the Q8 9.4, builds on the Kuwait Airways statement I've already referred to, first made by Mr. Justice Mance and then approved by the Court of Appeal in the same litigation. For reference, the Court of Appeal citing Mr. Justice Mance with approval is page 3781 of the bundles. Any exercise of interpretation, we say, should have had regard to the fact that once the Foreign Office had decided to make an exception to the 1980 principle, it should be treated as intending to make a categorical statement. And the likelihood of ambiguity or equivocation should have been treated as inherently low from the outset. The fifth point, perhaps an obvious one, at 9.5 of our case, to emphasise the express incorporation into the Foreign Office statement of the earlier 4th of February 2019 statement, again using the critical term recognises, stating that the recognition would be until credible elections could be held, and confirming that as at March 2020, when Mr. Justice Knowles was being responded to, that remained the position of Her Majesty's government. Now, the incorporation of the February 2019 statement was important, we say, in both substantive and temporal terms. And far from assisting the Maduro board, as it appears to try to suggest in its printed case at various points, it stands firmly in its way. In terms of substance, the use of the verb recognise could not be clearer and can only sensibly be viewed as of being of real significance. As Mr. Justice Tier held at first instance, the word itself denotes a formal statement of consequence, and it is a word which Her Majesty's government would not use casually, let alone in a formal statement to the court, but would use deliberately. That's Mr. Justice Tier at 33. The reference to the 4th of February 2019 statement was making it clear, of course, recognition had occurred on that date, but it was also making it clear that recognition of status then conferred was immediate and effective. No question of aspiration, no question of entitlement, immediate and effective status. And it was also making it clear that the position in March 2020 remained as it was in February 2019. So making it explicit, we say, that whatever might or might not have occurred in informal discussions or otherwise, whether in terms of diplomatic dealings or contact between Her Majesty's government and the Maduro regime or otherwise, was irrelevant. They were swept from the board because the recognition statement was made as of February 2019 and it was being made explicit that nothing had changed in the intervening period. So that alone, that last point alone, we say, disposes of what is really the centrepiece of the Maduro board's case and what appeared to be of most concern to the Court of Appeal. All of the assertions about diplomatic dealings after February 2019 were of no relevance to and did not qualify Her Majesty's government's expressly stated position as to who it recognised as president. Now, that point, of course, is also now firmly supported by the Foreign Secretary's submissions on this issue of interpretation. I'll just give the references: 3.3, 54 to 56, 62 to 64, all of which we gratefully adopt. The sixth point at 9.6 underscores the immediacy and effectiveness of the February 2019 recognition. The use of the word now on the 4th of February was making it explicit that the 4th of February represented a watershed moment of consequence, not merely a statement of political support for Mr. Guaidó, not merely a condemnation of Mr. Maduro, both of which there had been plenty of prior to then. As Mr.
The state of the United Kingdom now recognises Guaidó as President of Venezuela meant that Mr. Guaidó is now recognised as President of Venezuela, and there wasn't really a lot to argue about, but these proceedings seem to have proved that wrong.
They have, my lord, but it's always been our submission that there hasn't been a lot to argue about. And Mr. Justice Teo, as you've seen, reached his judgment that there really wasn't much to argue about pretty quickly and pretty succinctly. So I'll move on, my lords. I mean, we've made the additional points on interpretation at 9, 7, 8, and 9 and 10. Even leaving aside four corners and the important guidance, we say that the Court of Appeal did not, with respect, fully take on board. Everything pointed towards recognition of Mr. Guaidó and Mr. Guaidó alone as President of Venezuela. Perhaps one point that's worth emphasising, although with respect we agree, it's a pretty obvious point. Not a single reference anywhere in either the 4th of February 2019 statement or the March 2020 statement to Mr. Maduro as an individual. Plenty of reference to corruption, to oppression of human rights, to oppression of the Venezuelan people, but nothing at all about Mr. Maduro as an individual. A difficult platform, we would respectfully submit, to mount an argument that Her Majesty's government is leaving open some form of recognition for Mr. Maduro. Well, Lord, I don't want to take the court's time. I've probably done it too much already, simply repeating points that are, I hope, clearly enough set out in our printed case. But that's all I really wanted to emphasise, I think, on the first error. Taking a very straightforward approach to interpretation on the words actually used, and once one acknowledges, I'll come to it in more detail, once one acknowledges the sweeping of diplomatic dealings from the board, which again I perhaps should emphasise, aren't referred to at all in the statements. There's really no difficulty at all in an interpretive exercise. Fascinating though it has been, maybe less fascinating for the court to hear from me on it now, fascinating though it has been to go through the jurisprudential archaeology of looking at the Russian Revolution and the invasion of Abyssinia and so forth, one never really should have needed to get anywhere near that territory. So that's the first error. Basic approach to interpretation leads to the Guaidó board winning. The second error, my lords, is the important one of principle. The Court of Appeal arrived at its conclusion that the March 2020 statement was ambiguous or less than equivocal by reference to at least four matters which the court did not suggest were addressed in the statement at all. I'm referring here again, of course, to paragraph 123 of the Court of Appeal's judgment. Firstly, the pre-February 2019 dealings with Mr. Maduro as head of state. Nothing about that in either statement. Secondly, the maintenance of diplomatic relations with the Maduro regime. Again, nothing about that in the statements, as I've just said. Thirdly, the fact that Her Majesty's government had not accorded diplomatic status to Mr. Guaidó's former representative in London. Again, nothing about that in the statement. And fourthly, what was said to be the established existence of a distinction between recognition de jure and recognition de facto, which with respect was nothing like as established as that proposition suggests. Now, as I've already indicated, and as I will submit when we reach what we say was the Court of Appeal's fourth error, None of those matters should, as a matter of substance, have led the court to the position that it arrived in. But our argument at this stage, the second error, is that they should simply not have been taken into account. Once Her Majesty's government had spoken, that statement should have been treated as both conclusive and exclusive. Each of those four matters instead fell outside the four corners of the recognition statement and the court's letter which had preceded it. And those alone should have been the source material for the interpretative exercise the court was engaged in. Now, we respectfully submit that this follows from the one voice doctrine and the nature of the prerogative and the separation of powers in this jurisdiction which it reflects. As it was put by Mr. Justice Andrew Baker at first instance in the earlier Bresch case relating to Libya, the one voice principle is a fundamental principle of English law and an aspect of the unwritten constitutional bedrock of the United Kingdom. Once Her Majesty's government has recognised a particular person in this regard and so notified the court, this is in substance the voice of the sovereign as to a matter upon which she has an absolute right to direct the answer. It is also, we say, firmly established as a matter of authority, including in the three decisions of the House of Lords, Kellington, Carl Zeiss and the Aranzazu Mendy, and the further decision of the Court of Appeal, Gurr, which we cite in our printed case. Now, our full position in relation to this is set out at paragraph 17 through to 25 of our printed case. It's again entirely consistent with the approach of the Foreign Secretary's printed case at paragraphs 12 to 19, 45 to 46, and 59 to 60. And the Maduro Board does not engage, in its printed case at least, expressly with this argument in any detail. All it does is endorse what the Court of Appeal said at paragraphs 107 to 111 of the judgment below, and provide what it submits to be a useful illustrative example, I should say, of the importance of context, by saying that the word fire can mean different things according to the circumstances in which it is used. A logical proposition which we, of course, don't dissent from. But those submissions, my lords, we say, provide no answer at all to the principles and authorities which stand in the Maduro Board's way. So far as the Court of Appeal is concerned, its reasoning on this issue was extremely brief, notwithstanding its recitation elsewhere in the judgment of at least some of the key passages from the authorities we refer to and which I will go to. The Court of Appeal asserted at paragraph 110, Appendix 1, page 64, that if a statement was not clear and unequivocal on its face, it would be necessary to construe the terms of the statement in the light of its relevant background, citing a passage from the earlier Court of Appeal decision in Bresch, as it did so, notwithstanding the distinctions with Bresch that we've identified at paragraphs 41 and 42 of our printed case. In Bresch, as the court will recall, there was a very live issue as to whether any statement of recognition had been made at all. The Court of Appeal held that it had, and it did so by reference to the terms of the statement itself, and then they looked at additional material to confirm that conclusion. But it's also right to note that in Bresch, there was no argument about the four corners principle at all either. So far as the broader context about the word fire, and context being important generally, is concerned, the authorities show that in this situation, that context is provided, and provided only by the letter from the court which has preceded the recognition statement. Now, the authorities which we contend to be most clear and helpful and definitive on this regard, as I say, are Kellington, Carl Zeiss, Gurr, and, if I need to go to it, Bresch itself. We address Kellington in our printed case at paragraphs 19 and 20, and the judgment itself is in the main authorities bundle at tab 165, page 2538. All the Maduro board says in response to the passages we cited in our printed case from Kellington is that Kellington was a sovereign immunity case and so it's of no interest for present purposes. Well, needless to say, we don't agree. The case was concerned with statehood, the ruler of the relevant state, and an argument of state immunity invoked in opposition to the enforcement of an arbitral award against the government of Kellington. And as we explain in our printed case at paragraph 19, the House of Lords accepted as conclusive as to the sovereignty of Kellington a statement in a letter from the Colonial Office stating that Kellington was an independent state and its Sultan its sovereign ruler. It did so notwithstanding the fact that the letter enclosed an agreement between the Sultan and the then sovereign George V, which was on its face inconsistent with such independence and sovereignty because of its reservation to the king of political relations with foreign powers and because of an agreement in matters of administration to follow the advice of an advisor appointed by the king. This was also, as a matter of interest, another case where the court granted the Attorney General permission to intervene and to address the court as to the lack of ambiguity in the relevant executive statement. As we see from page 802 of the report, the Attorney General was firm that the Colonial Office had sent forth no uncertain sound. Now, the speeches of their lordships, we respectfully submit, disclosed a carefully considered, principled and soundly reasoned basis not to engage in a wide-ranging factual inquiry in order to interpret a statement freely given by Her Majesty's government in a context touching upon foreign relations, relating, amongst other matters, to the status of a foreign ruler. Each of the passages that we've set out in our printed case at paragraph 20 support our position that in such a context, the court is simply not permitted to search for material beyond the statement it receives from Her Majesty's government to find ambiguity in such a statement where otherwise there is none. And they explain why this was so. And more broadly, of course, Kellington and each of the authorities we cite illustrate that the one-voice doctrine is called the one-voice doctrine for a reason. It is focused on what Her Majesty's government has said in formal statements to the court and the need to ensure consistency between such statements and the approach of the courts in response. It is simply not concerned with wider questions of Her Majesty's government conduct, not reflected or addressed in those statements. Viscount K first at page 808 of the report, 2549 of the bundle, emphasised the desirability, when considering the precise point at which sovereignty ended and dependence began, of any determination being by Her Majesty's government rather than by the courts, because of the potential difficulty of the task and the ability of Her Majesty's government to have regard to all the circumstances of any given case. And he then went on at the foot of 808 over to 809 in the report, in the specific passage we've cited at 21 in our printed case, to describe the undesirable conflict which might arise if a court took a different view to that expressed in a definite statement made. Viscount Finlay at 2554 in the bundle, page 813 of the report, identified the key question as being whether the Sultan was a sovereign prince, and continued with a passage we've set out at paragraph 22 of the printed case. He emphasised that the status of foreign powers was one of the matters on which the courts were bound to take judicial cognizance, and the conclusive nature of the information provided to the court by Her Majesty's government. As he put it at page 813, such information is not in the nature of evidence. It is a statement by the sovereign of this country through one of his ministers upon a matter which is particularly within his cognizance. Just above that, in any such matter, the court is bound to act on the information given to them through the proper department.
Matters particularly within the cognizance of the executive may be absolutely key to the nature of the exercise, it seems to me.
Absolutely. Halfway down the next page, my lord, page 814, 2555, Viscount Finlay addressed the dividing line between sovereignty and dependence, and it acknowledged that it was obvious that to a great extent the Sultan was in the hands of Her Majesty's government. And he recorded the fact that the House was being asked to say that it was for the court, in a judicial capacity, to decide whether the restrictions were such that the Sultan had ceased to be a sovereign. But he concluded that the House simply had no power to enter into any such inquiry. At 815, 2556, again just about halfway down, passage beginning, "There is no ground," he expressly rejected the idea that because the questions of sovereignty involve questions of law, that meant that it had to be determined by the courts, and concluded with the clear statement that the answer of the king through the appropriate department settled the matter, whether it depended on fact or law. And that sweeps away entirely, we say, the idea that the Maduro board can invoke what might or might not be the position or the correct approach in international law to issues of identification of head of state. Once a recognition statement has been made, that answers the question definitively. On the issue of manifest falsity, which has been floated by the Maduro board, but is now apparently not to be pursued, his lordship then addressed the arguments that different indications were contained not merely in wider context, but different indications were contained in the documents actually annexed to the Foreign Office letter, or the Colonial Office letter, I should say. And he rejected those different indications.
That's page
816, 2557.
Sure.
And it's again just over halfway down. Having referred to the enclosed documents, finding that in the end they don't actually negative the view expressed, he then says, "But as I have said, the question is not for us at all. It has been determined for us by His Majesty's government, which in such matters is the appropriate authority by whose opinion the courts of His Majesty are bound to abide."
You didn't take us to it, but there's a similar statement by Viscount Cave. If one goes back to, back to 25. Let's see, 2546. In the second paragraph of his speech, he says that it's been for some time the practice of our courts to take judicial notice of the sovereignty of a state, and for that purpose to seek information from a Secretary of State, and when information is so obtained, the court does not permit it to be questioned by the parties. Information of this character was obtained from a Secretary of State and accepted without question in, and then there's a list of authorities. So although, in fact, the House of Lords had heard argument in that appeal, Viscount Cave is really speaking very, very similar language to Viscount Finlay about its conclusive character.
He is, my lord, and I think, it may be that Miguel certainly was a Court of Appeal case, and so that's why it was felt legitimate to even run the arguments. But Viscount Cave is certainly there saying, until now, everyone has treated these statements as conclusive. Yeah. And then he and every other member of the Judicial Committee then go on to explain why that remains the case. Lord Dunedin, in the passage we've set out at 23 of our printed case, page 2561 of the electronic bundle, 820 of the report, emphasised that recognition came and came only through the mouth of the Minister of the King. It was the statement that mattered, and only that. As he put it in the sentence preceding that we've quoted in 23 of our printed case, the Home Sovereign has in him the only power and right of recognition. Lord Dunedin also expressly rejected the idea that it could be right for the court itself to examine a particular person's supposed attributes before determining whether or not they were in truth sovereign. And in doing so, he emphasised the implications for comity were the courts to challenge such a recognition. And that's all in 23 of our printed case. Lord Sumner was of the same view. He explained at page 824, 2565, that it was the prerogative of the Crown to recognise states or chiefs of states and to determine from time to time the status of foreign powers. And on the same page, in the passage we've cited at 20(4) of our printed case, he emphasised that where a statement from the Colonial Office had been given, no other evidence was admissible or needed, and he expressly rejected the idea that it could be open to the court to determine whether the Colonial Office had rightly concluded that the Sultan was entitled to be recognised as a sovereign by international law.
He seems to be suggesting it's the best evidence.
Yes, he puts it in terms of best evidence, my lord, and at the foot of the page, he also referred to cases where the Crown had not accorded unconditional recognition or had used some vaguer phrase, and he, on one reading, could be taken to be expressing the view then the court would have to collect the meaning for itself. Now, 2 points on that. Firstly, it's inconsistent with his primary conclusion and indeed with the conclusion of all other members of the Judicial Committee. Secondly, it was considered and expressly rejected by Lord Atkin in the Aranzazu Mendi as wrong. Notably, though, in passing, this was a passage cited by the Court of Appeal in this case at paragraph 107 of its judgment. Just for reference, or perhaps to go to...
So which passage are you referring to on page 824?
It's at the foot of 824.
There may be occasions, yes.
2565, where he's contemplating the court collecting the true meaning for itself, the last 3 lines. There may be occasions when, for reasons of state, the answer to the question has to be temporary, if not temporising, or even where some vaguer expression has to be used. Now, obviously, our primary position is we're not in that territory here. In such cases, not only has the court to collect the true meaning of the communication for itself, also to consider whether the statements as to sovereignty made in the communication and expressions and so on mean the same thing. So contemplating perhaps at its highest some residual role for the court. But as I say, if that is what's being suggested, or if, to use the term best evidence, what's being suggested is only that this is one form of quite powerful evidence that falls for consideration, that view is expressly rejected by the House of Lords in the Aranzazu Mendi, which we have at 2956. In the same bundle, tab 176. Which is, of course, the case most associated with the one voice principle because of the way Lord Atkin expressed himself. But on this point, it's page 2956, page 264 of the report, having referred to Lord Sumner. With great respect, I do not accept the opinion implied in the speech of Lord Sumner in that case, Kellenton, that recourse to Her Majesty's government is only one way in which the judge can ascertain the relevant fact. The reason is, I think, obvious. Our state cannot speak with 2 voices on such a matter, the judiciary saying one thing, the executive another. Our sovereign has to decide whom it will recognise as a fellow sovereign in the family of states, and the relations of the foreign state with ours in the matter of state immunities must flow from that decision alone.
The logic of it is, is a logical explanation given by Lord Dunedin, 2561, that where he says that once you trace the doctrine for the freedom of a foreign sovereign from interference by the courts of other nations to comity, you necessarily concede that the home sovereign has in him the only power and right of recognition. If our sovereign recognises and expresses the recognition through the mouth of his minister that another person is a sovereign, how could it be right for the courts of our own sovereign to proceed upon an examination of that person's supposed attributes to examine his claim, and refusing that claim, deny to him the comity which their own sovereign has conceded? That's quite a... you understand the logic of it.
Yes, absolutely, my lord. It's a profound constitutional point, and it's why we've emphasised that point, that very passage at paragraph 23 of our printed case. We're not going to get there because of the approach that's now being taken by the Maduro board. But this passage also is a very vivid illustration of the fact that we are talking about recognition on a subject right at the top of the scale of foreign policy considerations. Who does our sovereign treat as another sovereign?
Yeah. Lord Dunedin was rather unusual in being a judge who was both a former law officer and also a former Secretary of State.
Well, he will then perhaps be better placed than many to have embarked upon this exercise, but is still saying, with my judicial hat on, I won't do it.
It seems like all these statements make it abundantly clear for the government and not the courts to look at the facts and decide who is made a state. I don't at the moment see that they say that if there is ambiguity in what the government has said, you can't look at anything outside the letter. You haven't yet shown us anything that says that.
Well, if we look at Kellington, my lord, the approach in Kellington was there was a letter from the Colonial Office saying this man is sovereign. There were annexed to that letter a whole series of documents which Viscount Cave and others said they would have great difficulty, if it were a matter for them, in concluding, led to a conclusion that this man was sovereign.
Certainly.
But
they found no ambiguity in the statement, and therefore that was conclusive. It's not a matter for them to consider. I agree the line may be a thin one, but that's not the same as saying that if the statement in the letter was ambiguous, you couldn't look at the documents attached to try and clarify the meaning, perhaps.
Well, perhaps it's better for me to put it as a strong indication, my lord, that the correct approach is to focus upon the words actually used and not to go searching for ambiguity.
Well, that's a rather different point, which I think is the point you're making. But the error of the Court of Appeal was to look at extrinsic evidence and find there a basis for treating the statement as ambiguous.
Exactly. Absent the wider context identified by the Court of Appeal derived from matters not referred to in the statement at all, there's no explanation in the Court of Appeal of any ambiguity. So one doesn't even get there. We say Kellington is a strong indicator, my lords, that it is only the letter that comes back, or the answer that comes back, that is available. We'll see in a moment in the Court of Appeal in Gurr, coming closer to the present day, the Master of the Rolls describing the raw materials available to the court as being the 1980 policy statement, the letter asking the questions, and the answer that comes back. And that may be a more direct authority on the point my lord's just put to me, but entirely consistent with the overall direction of travel and theme, that once the sovereign has spoken, that is it. In our case, of course, we have the luxury of now knowing it doesn't matter ultimately, because the sovereign has spoken twice. We say, at the very most, if you have ambiguity on the face of a statement, you go back to the sovereign and you ask again. And that, in substance, has happened in this case, at least From the perspective of the Court of Appeal, they found ambiguity, they identified a residual question. That residual question has now been definitively answered. But no support anywhere for the idea that it could be open to a court itself to treat a statement by Her Majesty's government as if it were a contractual document and go searching for a wider factual matrix. And that is so, my lords, we would say, for very good reason, because in the context of a contractual interpretation analysis, the court faces none of the public policy constraints that we've just been discussing about sovereignty, about the one voice principle, about comity. It's simply a question of identifying the objective intent of the parties against the background of the reasonable factual matrix objectively available. In this context, what matters to do justice to the one voice principle is to know the subjective intent, ultimately, of the sovereign. And the best place to look at that, and we respectfully submit the only place properly to look at that, is the four corners of the correspondence and the statement made.
It's referred to in the statement.
Yes, that could open the door, my lords, if there'd been a reference to documents in the statement or a reference even to subjects in the statement. It might be necessary or legitimate to look at what was actually meant by that. But here we're nowhere near that territory where, as I say, 4 of the 5 matters are just not addressed in the statement or referred to at all. So that's what we say about Kellington. I should say, I think I've dealt with Lord Sumner, and I now digress to Lord Atkin's views on Lord Sumner. I should also emphasise perhaps Lord Carson, which, going back to Kellington at 2571, page 830, this is the point we've made at 25 of our printed case.
He makes it very clear that if he had been able to look at the other materials, he might have taken a different view, but he can't.
That's it, my lord.
Yes.
That's the point I was grappling with in my response to Lord Leggett just now.
Yeah.
Sorry, which page is that, Mr. Rocking?
I'm sorry, my lord, it's 2571, and it's also it's page 830 of the report, and it's summarised in our printed case at 20, subparagraph 5. And this is perhaps of some assistance, at least, on this issue in supporting the submissions I've just been making. Lord Carson addressed the matter in the way we've summarised it at 25. He again rejected as irrelevant, not relevant context, he rejected as irrelevant whatever international law might say in the face of a definitive statement from the executive. He acknowledged the great difficulty in reaching a conclusion that Kellington was independent and its ruler sovereign, having regard to the enclosures to the Secretary of State's correspondence. But he concluded that it was unnecessary to pursue that investigation or consider the other ample materials which had been presented. That was because the court was bound to take judicial notice to the status of any other country in accordance with the information afforded to them by the proper representative of the Crown. And it's a particularly difficult exercise, we submit, in the context such as this, to go down the route that the Court of Appeal considered legitimate, when post-1980, the policy is not to recognise at all. And as Mr. Justice Mance put it, instead, when Her Majesty's government does recognise, she's to be taken as indicating a more categorical attitude. It's a particularly difficult exercise to say that against that background, it's legitimate to go searching for wider materials. And Lord Carson explained, again, the policy reason underpinning that rigorous, focused approach. If the courts, and this again may be a more substantive answer than I was able to give to my Lord Leggett a moment ago, if the courts are presented with a statement from Her Majesty's government, but nevertheless go beyond it, roaming looking for more material, or even looking at material attached to such a statement if it's in conflict with the statements that's made, then there is a risk that chaos and confusion would follow. And then Lord Carson explained that a similar point had been made by Lord Isha as Master of the Rolls and Lord Justice Kay in the Sultan of Johor case, which we refer to in our printed case in footnote 9. The whole point of the one voice doctrine and of the executive statement which triggered its application was, as the Court of Appeal had put it in that case, to avoid contentious inquiry. May be helpful, as we just to take 2 minutes on this. The Sultan of Johor case, the Court of Appeal the Court of Appeal is in Supplementary Authorities Bundle 2 at page 4055. .4043 is where the report starts. 4055 for these purposes. Lord Isha we have at 4052, page 158. Towards the foot of the page, where there's reference made to the earlier case of the Chartier, where Robert Phillimore had been prepared to look at wider historical and other sources. The Master of the Rolls acknowledging that that was what had occurred, and then going on, I know he did, but I'm of opinion that he ought not to have done so. That when once there is the authoritative certificate of the Queen through her Minister of State as to the status of another sovereign, that in the courts of this country is decisive. Therefore, this letter is conclusive. The defendant is an independent sovereign. And then at 4055, Lord Justice Kay, page 161, referring to the inquiries that had been made, and then the last, and the answer given, it was contended that the letter was not sufficient, did not satisfactorily establish the status of the defendant as an independent sovereign. I confess I cannot conceive a more satisfactory mode of obtaining information on the subject than such a letter, proceeding as it does from the office of one of the principal secretaries of state and purporting to be written by his direction. I think it must be treated as equivalent to a statement by Her Majesty herself. And if Her Majesty condescends to state to one of her courts of justice that an individual cited before it is an independent sovereign, I think that statement must be taken as conclusive. Now, I take my Lord Legate's point that they're not in terms saying that it's, the Master of Rolls gets pretty close to it, saying it's completely impermissible to ever look at anything else. But those passages and all the other passages I've cited are very strong support for the public policy constraint that applies in this context, a public policy constraint which is entirely absent from a context of interpretation in the commercial field where one might well see it as appropriate and legitimate to look at wider material.
One of the interesting aspects is that Lord Justice Kay, in the first sentence, describes the status of a foreign sovereign as a matter of which the courts take judicial cognizance. And I think in the Callantan case, the expression judicial notice was used. And that would suggest it's not a matter of proof by the leading of evidence, which has a bearing on the Court of Appeal's approach.
Exactly so, my lord. It's not a matter of proof at all. Once the foreign sovereign has spoken on the issue of recognition, that is it. Proof only comes...
Say that the prohibition against looking at facts extends to facts which are relied on as part of the factual matrix. Which I haven't explained it very well. The prohibition inherent in the doctrine, which is that you look at the state, you follow the statement of the Secretary of State against looking at what the facts actually are. Perhaps that it extends to looking at facts for the purpose of of establishing a factual matrix with which to attempt to construe the document.
Yes, you don't get into that territory at all, my lord, please say. You simply look at what's in the letter. My lord, I don't know whether that's a convenient moment for the court. I think I've finished on, well, perhaps just 10 seconds. 3 key points from Kellington. First, on the issue of the status of a foreign ruler, the long-settled practice is rightly to seek a statement from Her Majesty's government. Secondly, once such a statement has been given, it is conclusive. And we say no other material is admissible or needed, even where the material is annexed to and referred to in the statement itself, and appears, by reference to the uncontested factual picture it presents, to contradict the statement expressed. And thirdly, it is simply not for the courts to inquire into the policies behind a statement or analyse whether, in making such a statement, Her Majesty's government has formed a correct or incorrect view of status as a matter of fact or of international law. Actual attributes, actual analysis of international law are rendered irrelevant once a statement has been made. That is, we say, the one voice principle. I thought I was going to go to Carl's Ice next, but
Yes.
I'll reflect further on how I can trim my submissions over the shortage.
Just for the sake of completeness, what I had in mind was Viscount Cave in Kellantan, page 2546, where he says it's been for some time the practice of courts, when such a question is raised, to take judicial notice of the sovereignty of a state, and for that purpose to seek information from the Secretary of State.
Yes, my lord. We looked at judicial notice, and interestingly, one can take judicial notice as to who is a member of the Supreme Court or the House of Lords, but not of other judges, apparently. There are interesting facets to it, but on this, it is off the table as a matter of evidential inquiry.
Well, thank you. We'll adjourn then and resume at 2 o'clock.
Certainly, my lord.